All right, welcome everybody to this session of the Senate Judiciary Committee. I will call it to order and ask the Secretary to please take the roll.
Senator Flores, Senator Orenshaw,
Present.
Senator Lang, Senator Nguyen, Senator Hansen, Senator Krasner, Senator Ellison, and Chair Scheibel.
Here, thank you so much. Please mark Senator Flores present when he gets here. We have a quorum. We are ready to get started on our agenda for today. We have one bill hearing. We also do have BDR introductions today. We will start with our bill hearing, and I'll invite our guest, Senator Stone, down to the front to give his presentation on SB 213. Please go ahead whenever you're ready. There's a button on this table that looks like a sticker.
Am I on now?
Yes, you are.
Okay. It turned red, so I was looking for a green light. Thank you, Chair Scheibel and members of the committee. I am Jeff Stone, and I represent Senate District 20 from Mesquite, including Henderson, southerly to Laughlin. First, let me say it's great to be back in Judiciary. One of the highlights of the 23rd session, our 83rd session, was serving on this committee where you see some of the most intriguing and exciting bills. And I regret not sitting on the committee this session, but hopefully in future sessions I'll get back on the committee. I'm pleased to present Senate Bill 213, which proposes to revise provisions related to the crime of unlawful dissemination of an intimate image. People in law enforcement can no longer tell the difference between real and AI-generated imagery, which does not help in the prosecution of such individuals. Current law only punishes actual imagery, but the harm remains the same to the victims. We should be doing more to protect the public, especially with the rise of AI advancement, giving way to revenge pornography and the increased rates we see in teen suicide from online bullying. A recent Forbes magazine article shows that 34 million AI-generated images are created daily, with at least 2,000 AI tools now available online contributing to these issues. Senate Bill 213 expands the definition of intimate image to include photorealistic images, digital images, electronic images, computer-generated images, and other pictorial representations that depict an intimate body part of another identifiable person but does not depict an actual body part of the person, or one or more identifiable persons engaged in sexual conduct but does not depict the person or persons engaged in that conduct. Senate Bill 213 aims to protect the public by expanding the crime of unlawful dissemination of an intimate image, and here are some key points on how it enhances public protection. In Section 1, the bill broadens the definition of intimate image to include not only photographs and videos, but also photorealistic, digital, electronic, computer-generated images, and other pictorial representations. This ensures that more forms of potentially harmful images are covered under the law. Section 2, intent to harm. The bill targets actions done with the intent to harass, harm, or terrorize another person. It criminalizes the distribution of intimate images without consent, especially when the images are created to appear as actual depictions of individuals by a reasonable person. You'll also note in Section 2, the protection for minors. This bill includes provisions that protect individuals under 18 from being prosecuted under the law. This law focusing on adult offenders who exploit or harm others through the dissemination of intimate images. The penalties: the offenders are guilty of a Category D felony, which carries significant legal penalties, thereby acting as, hopefully, a deterrent against such crimes. It's been suggested that the following amendments be taken, which are as follows. Section 2, subsection 4 will continue to be a part of the bill and will not require sexual registration. Section 3 will be stricken in its entirety. Madam Chair, that completes the bill, and I'd be happy to answer any questions if any members have any.
Thank you so much, Senator. Wonderful to have you back here in Judiciary.
Thank you.
I'm sure we do have some questions. I will start with Senator Wynn.
Thank you for bringing this bill, Senator Stone. I don't know if you know this, but now I'm going back a long time to my law school days, but I remember there being like U.S. Supreme Court like opinions around like First Amendment and some of these, I got at the time, and this was like 20, 30 years ago, where some of these images were unfortunately protected. I tend to agree with you that the technology and the way that these, computer-generated images, sometimes you can't tell the difference now. So I'm wondering if you are aware of any changes to some of that, like legal precedents, and whether or not how this would be distinguished from some of those concerns that have been brought up in lawsuits around First Amendment issues.
Thank you for the question, Senator Jeff Stone. For the record, I'm not aware of any recent Supreme Court cases that prohibit or that criminalize the dissemination of images that are not true images. I will say that this bill has passed in other states, and to my knowledge, it has not been challenged thus far.
What states has this passed in?
In the state of California.
Okay, because I see here about an identifiable person, but it also says computer-generated images. So is the intent when someone takes like an actual image of a person and generates like inappropriate images with that person as the like template?
Yes, Senator Jeff Stone, for the record, that certainly could be one of the cases.
Thank you.
We'll go next to Senator Hansen.
Thanks, Madam Chair. Kind of we're entering a world that even Orwell didn't picture, you know what I mean? Seriously. I actually had an experiment. My grandson, who's in 6th grade, part of his science project, sent to Alexis and I think it was 20 images, and we had to pick which was AI and which were actual real pictures. And we flunked. We both got 50%. So this technology is getting so advanced that, yeah, this bill is necessary, because technically you can be doing child pornography without involving a child at all, but the imagery is so believable that, for the people that are have those kind of appetites or whatever that we're obviously trying to discourage and suppress, they can have that fantasy world or whatever you want to call it without actually involving a child. So I assume that's what this bill, the real genesis of it and the intent behind it is to prevent that kind of stuff.
That are generated a day, and you have over 2,000 tools to help somebody come up with these fake images, if you will, that are very hard and hard to distinguish from reality. And right now, you can only prosecute people that use actual photos and try to extort or bully children. This now expands that now, where if it's generated, the image is generated by AI, that it gives tools to the prosecution to go after some of these nefarious people.
Now, we already have on the books now laws that, for example, you get some teenage girl who sends a picture to her boyfriend or whatever, and then he then distributes it to be cruel. That I think is currently wrong. But now what you're basically saying in this bill is I can make a really well done image of her face that isn't real, put it on a fake image, and then distribute that, which wouldn't be illegal if this law doesn't pass?
Senator Hansen, you're absolutely correct. That's the reason why we need to bring this bill forward, to make sure that we hold those accountable for manufacturing these false images of people and creating very unfortunate scenarios for these victims.
Good. Sounds like a great bill to me. I'll be intrigued to hear all the testimony for and against, but seems like it's absolutely necessary because of the kind of world we're entering. Thank you, Madam Chair.
Thank you.
Thank you. And before we move to the next question, I did want to go back to legal just to clarify on the Supreme Court decisions that have addressed these types of images, or kind of images.
Thank you, Chair. Back in 2002, the U.S. Supreme Court in the Ashcroft case had found the federal statute was unconstitutional because it applied to persons who were not identifiable as an AI computer-generated child pornography. And this bill actually relates to identifiable persons, so you wouldn't have the same constitutional issue.
Thank you. Yes, go ahead, Senator Wynn.
Is that why you included that language about identifiable person? I mean, I wish our Supreme Court actually would catch up. I think some of these fully computer-generated, child pornography is what it is just as detrimental to all children, although it isn't an identifiable child that is in those pictures. But is that why you kept it to the identifiable portion?
Thank you, Senator Wynn, for the question. Senator Chestone, for the record, in working with LCB, it was their recommendation for those reasons that we put that in there like that.
All right. I think we had a question from Vice Chair Flores. Go ahead.
Thank you. And thank you for the presentation. I think everybody's always concerned about these conversations. And I think often when we come into this building, when we start engaging in the conversations, however, we hit legal crossroads where that's where it becomes complicated because sometimes we're catching a much wider net than we wanted to. I'm concerned, I understand, and I also, and legal could correct me, I think United States v. Williams, yeah, that was a 2008 Supreme Court case. In that case, it was where there was like an advertisement. It was also computer-generated images of children, but they were advertising it as legitimate child pornography. And in that case, I think the ruling went in the other way, where they could criminalize it in that sense. But what concerns me in this scope, it sounds like we're trying to go after bullying, and I respectfully agree with that. But I wonder if there's an opportunity for us to look at our bullying laws now and really channel the energy there on how we could address that versus, I've got friends and family members who have group chats who take images, or there's websites that do it now for you. They'll take your face, and I've had one sent to me where I was dancing as an elf, and I think Elfster is the one that did it, and there's just all these other random companies, right? And it's cute and it's funny, and it's not intended to do anything beyond that. But I know that there's just this area, this such broad gray area of how folk play with people's faces and do things, but it's fake at the end of the day. It's made up. It's not real. So I'm curious to know if you looked at this through the lens of bullying, looked at the statutes that pertain to that, and said maybe we can expand there to avoid some of the constitutional questions that are out there, particularly in that 2002 Supreme Court decision in Ashcroft v. Free Speech Coalition, because I think that's where the real concern was at. But I was just curious to know if you tried that, you went through that avenue, and then said that's not going to work for some reason, and then you moved in this direction.
Thank you, Senator Flores, for the question. Senator Chestone, for the record, I didn't examine the bullying statutes comprehensively in the state of Nevada. This again was emulated from a California bill. I'm still in touch with California legislators there that I once served with that shared in the idea, and to just explicitly have a bill that talks about basically AI-generated pornographic images or other unflattering images that are causing a lot of distress to innocent people through, again, revenge porn, bullying. That may be an appropriate avenue for a bill like this, but to me, having a dedicated piece of legislation that goes into a little bit more detail with AI, and I think we all agree that there's some blessings with AI, but we also see some curses with AI, and I want to get ahead of this before we see some individuals severely hurt and children bullied to the point where they would consider even suicide.
Well, thank you, Madam Chair. I'm curious to know, and ultimately you want to go after the individual who created the image, period. Because I'm thinking of a hypothetical where, say, person A creates the image, shares it with A through Z, and the bullying occurs with person Z, right? Person Z gets it, and they're the ones that engage in the bullying activity. They're the ones that are using that to attack person 1. Person A created it. Person 1 is a victim, but person Z is the one that's weaponizing it. That's the person that's going after, sharing with everybody, showing it to person 1, making that poor human being cry. In that hypothetical, would we treat person Z as the person who created that image, even though they didn't do it? They just happened to get it and they ran with it. Would we treat person Z differently? Would we have to trace it all the way back to person A? Do we track all the people in between? I'm just trying to understand, how do we get from A to Z? The real conduct that we're trying to stop is the creation of the actual the AI image of person 1. But we're also trying to stop the weaponization of that, which is person Z doing it. How we walked through that hypothetical and how we intended for this law to address that scenario?
Thank you for the question, Senator Flores. Senator Jeff Stone, for the record, this bill goes after basically the subject A, if you will, that is using AI to generate an image that is a false image of someone. Obviously, I would love to go after accomplice Z, if you will, if that accomplice had the knowledge to know that this was AI generated and it was not representative of the real person that is being vilified. If there's a suggested amendment that you would entertain that would allow us to go after somebody that has knowledge that person A broke the law, if you will, and propagated this horrific image, I would certainly entertain that type of an amendment.
I don't mean to interrupt, but I think legal might be able to weigh in here as well on who would be covered under this section of the statute as a whole.
Thank you, Chair. Yes, the current statute, and as it would be expanded in the bill, relates to dissemination of the image, not the act of creation of it. So every person down the line, including the very last one, as long as that person disseminated it, would be guilty of violating this statute.
Okay, thank you. And so in that scenario, based on the feedback that we just got, the intent would be, even if it was shared 100 times as a joke by 100 different people, then in that scenario, according to what legal just clarified for us, it would be your intent that every single one of those individuals be prosecuted the same? Is that correct then?
Thank you, Senator, for the question. In response to legal counsel, that's what the bill ultimately is going to do.
And the reason I'm saying that, sharing the image between person 1, 2, 3, or A, B, C, and D, I always feel like the intent may be different. Oh, did you see this picture? How stupid it is, or how funny it is, or sharing it because they're concerned. Oftentimes, and in this building, I think we all relate to that, where there are scenarios where something gets put on the media or something is out there, and it might be something that's horrible, right? They're attacking us on the media, and we'll share information immediately, but not with the intent to cause any harm. Really, we're just sharing it. Hey, have you seen this? Have you seen that? I'm curious to know if those individuals would actually get captured. And the reason I brought up the bullying statute is because I do believe that the person who may have one intent versus the person who's weaponizing it at the very end of that chain of command. So just curious. Madam Chair is pointing at section 2, where she's making it abundantly clear that there is an intent element in there. So that clarifies my point.
Okay,
Thank you, Mr. Stone. Senator Stone.
thank you.
Other questions from, Senator Hansen.
Thanks, Madam Chair. Actually, kind of a little bit of a, first of all, in my mind, if anything to do with child pornography, we want to err on the side of caution, right? We want to, but the interesting part of the bill, and maybe our legal counsel will have to do it, if the false image is not specifically identifiable to a human being, you know, the iris face on it or something, then it's not, we couldn't prosecute in the absence of that? Is that, because the impression I got when you mentioned the 2002 Supreme Court decision was kind of like you have to have an identifiable person to make this a crime. And if that's the case, then this is kind of a scary gray area, because now you can make child pornography that if you can't specifically identify the human being that it's supposedly modeled after, it's not a crime?
Thank you. The analysis of whether you have an identifiable person or not it really goes to the constitutionality of the statute and whether it violates the First Amendment. Because if you don't have an actual victim, that was the reasoning of the Supreme Court, then you don't have actual child pornography, and that may well be revisited sometime soon by the Supreme Court. It could lead to a different conclusion. There are a lot of states now that have AI porn prohibitions. I think it's maybe like 30. So at some point there may be further case law that addresses that issue.
Okay, well, no, that makes sense, because obviously the technology's probably advanced substantially since the 2002 decision. So I would certainly hope that even if you couldn't specifically identify the image and tie it to a person, it's still child pornography, and we should aggressively try to suppress that kind of stuff. I mean, I'm a huge supporter of the First Amendment, but when it comes to children, I think that there are very good, reasonable reasons to have statutes like this. I'm just a little worried that we actually are leaving a carve out in this bill, because it does say identifiable person, and therefore, if you couldn't, if you're the law enforcement folks and you're trying to prosecute somebody for child pornography and you cannot tie that actual image to a human being, can they walk? It's kind of a bit of a dilemma to me. Thank you, Madam Chair.
Thank you. And I'm going to jump in here and say that good news is we have a bill hearing tomorrow on a child porn AI bill, which is distinct, and it's a whole separate section of the NRS from the dissemination of an intimate image, which legal can correct me if I'm wrong, I think of as kind of the only illegal pornography involving adults, because that's when someone is essentially creating pornography or an intimate image, a sexually explicit image, without that other person's consent. And that's why we often call it revenge porn, is because it often comes in that context where somebody is trying to, hurt, harass, terrorize the other person by, it used to be sharing photographs that they had previously provided with their partner, and then they break up, and now they're providing them to everybody. But as we've been discussing today, it's evolved and it's morphed, and now it's taking an innocent picture and turning it into something that is graphic. Did you want to say anything else, Senator Stone, in response to Senator Hansen?
No, I'm content with the answer of counsel. Thank you.
Okay. If there are no other questions, okay, Senator Orenshaw.
Thank you very much, Chair, and thank you, Senator Stone, for bringing the bill. I appreciate the intent. One concern I have is that maybe the net is going to be too broad here. When I read the words, and I'm looking at section 1, sub B, at line 10, a photorealistic image, I don't see that has to be created by a computer or by AI. And, I'm thinking, we're all from Southern Nevada. In Southern Nevada, there's lots of impersonators who impersonate famous actors, personalities. So let's say you had someone who wants to make a movie using an impersonator who splitting image of a famous actor, and they want to make one of these kind of movies. And 9 out of 10 people look at the movie and they're like, wow, that's that's, the big movie star. That's definitely him. But it's not. It's, John Smith, who happens to be almost double of the famous movie star. I'm just worried this might be, while the famous movie star may not like that this movie's being made, it's not an AI creation. I don't think it's who you're trying to catch.
Right.
And I'm a little worried that maybe the language needs to be tightened up there, because I'm worried that might catch that scenario. And maybe I'm wrong, maybe I'm misreading it, but I do appreciate the intent of the bill. I'm just thinking maybe there needs to be some tightening up there so that we don't catch someone who's, making something like that and, using someone who's a dead ringer for that famous movie star or something like that. But I guess it's more of a comment. Thank you, Chair.
Senator Earnshaw, thank you for the comment, and Senator Jeff Stone for the record. I'd be happy to work with you on language if it appears that it's going to create that type of a conflict, which is not the intent of the bill.
Thank you, Senator Stone. Thank you, Chair.
Thank you. Any other questions? Okay, I have one or two. I wanted to focus on a section of the bill that I don't think we've really talked about, which is Section 2, subsection B, subsection 2. It's line 21 on page 3. That specifies that the person has to have not given prior consent to the distribution of the image, which when I read that says to me that it will be an essential element of the crime that consent wasn't given, which means that it will be the burden of the prosecutor to prove beyond a reasonable doubt that consent wasn't given, which would essentially, I can't think of a fact pattern where it wouldn't mean that you would have to have the cooperation of the person who's depicted or the victim in the case. And so I think that would serve, whether this is your intention or not, that would serve to differentiate this from cases of using like celebrities, for example. If someone wants to create an image, and I know that they're out there, don't ask me how, but I know that they're out there, of Taylor Swift, unless Taylor Swift is going to come in and testify, I never gave consent for so-and-so to create this image, we're not going to be able to prosecute that case. Whereas if the image is of somebody who we can bring into court who will say, I never gave them permission to alter this image, create this image, and distribute it, then we would be able to prosecute the case. So we're really talking about not just people who are real, but also people who are accessible, people who are cooperative, people who engage in the process with law enforcement to pursue these cases. Is that the idea?
Yes, thank you, Chairwoman Scheibel. That is the intent.
All right. Then with that being said, I don't see any other questions. We very much appreciate you presenting your bill today and answering all of our questions. We will open it up for testimony in support of SB 213, starting here in Carson City in person. And I don't see anybody in Las Vegas, so go ahead whenever you're ready in Carson City.
Good afternoon, Chair Scheibel, Vice Chair Flores, and members of the committee. Jennifer Noble on behalf of the Nevada District Attorneys Association. We'd like to thank Senator Stone and the co-sponsors for taking on what is a difficult issue as the discussions of this committee have borne out today. I think a couple of observations about this bill that I have are that, number one, there's a specific intent here. This is not a catch-all strict liability offense as it's described in the bill. We have to prove as the prosecutors that there is an intent to harm, harass, or terrorize a real person, and that there is the absence of consent, as the chair just observed. So looking at that, I have less concern than some of the members of the committee about catching unintended folks up in this legislation. And then I was also thinking about the lenses that we were talking about, the lens of bullying, thinking about child pornography. I also think it might be beneficial for this committee to think about this through the lens of misinformation and the growing problem of misinformation in the political sphere, just in our world in general. And I think that this bill would help address that as well. And again, I am no constitutional scholar when it comes to the First Amendment, but we do have regulations on the time, place, and manner of speech. The Supreme Court has approved those again and again. And I think this bill is a great start into trying to traverse this new landscape for the state. And I'm happy to work with Senator Stone or other folks if language needs to be refined. Thank you.
Good afternoon, Madam Chair, members of the committee. Jason Woodard, Nevada Sheriffs and Chiefs Association, and today I'm also representing the Washington County Sheriff's Office. Technology is a great thing. It makes our lives easier for law enforcement. It alleviates a lot of the burden for us or helps us to do more with fewer people. Unfortunately, though, legislation is slow to catch up with technology. Technology is constantly evolving, and it evolves at this rapid rate. And while there's all these great and positive things that technology can be utilized for, those same technologies unfortunately can be utilized for very devious things. This legislation helps to create a scenario where there are more enforcement avenues to us as law enforcement in cases of bullying and harassment, where these types of images are generated and utilized to do exactly that, to bully and harass victims and innocent folks. We will always be caught in the void of trying to catch up with technology, and we agree that there must be a balance, but this is definitely a loophole that needs to be closed in order to help us to thwart these types of cases and this type of harassment. Thank you.
Mr. Woodard, would you be open to answering a question from the committee?
Yes, ma'am.
Or actually, in general, for law enforcement, presently, if we had a scenario like that where you see any Nevadan who's just unfortunately being bullied, and there's all these dissemination of images now, and sometimes there's like a whole host of things you can see, social media and things, maybe they're bothering them, harassing them at their home. What do you utilize now to try to go after some of those offenders? What areas of the NRS can you use to try to protect and stop some of that conduct now? I was just curious.
Senator Flores, thank you for the question. Jason Woodard, Nevada Sheriffs and Chiefs Association. It's going to depend on a couple of things, so I'm not trying to be coy with your question, but there's a lot of variables in the particular case. Many times we see these cases and they involve juveniles, and so therefore the juvenile, it could be different with juveniles. In addition to that, one of the questions that we often ask is if we are presented a case where these types of images were presented to us as that form of harassment. And typically the harassment takes place as you're describing in kind of a 360 circumference. So the images might be posted in a workplace, the images are posted online, the images are sent via text and email, right? So to answer your question, we would look at all different avenues that first of all govern those communication, I guess, avenues, if you will. And in addition to that, one of the questions that we have to ask the victim is, are these actually images of you? And if they are not images of that victim, then our hands are tied in certain aspects of that enforcement because they're not those actual images. And I think, as I understand it, that is the actual intent of this bill, is to try and close that loophole so we can actually connect all those dots and be successful in bringing a case forward.
So am I correct in saying that really at times harassment would be the only, and then at times maybe not even that, but that's really the only thing you have in the toolbox now that you feel you can use?
Unless I had more specific key details, if we are sitting down doing a case study on a particular case, harassment is the one that comes to mind, and that threshold can be challenging at times.
Understood. Thank you.
Yes, sir.
I think we have another question, if you're willing, from Senator Wynn.
I'm wondering what kind of, have any, and this is for any of the law enforcement or even prosecutors that have come up, have you established any kind of relationships with or agreements with any of these social media platforms that are posting these images or not taking them down? When you see, even as it is now, like levels of harassment that might escalate or might be included in this bill if it was to pass?
Senator Wynn, thank you for the question. Jason Woodard, Nevada Sheriffs and Chiefs. As far as relationships go, these social media companies can be challenging for law enforcement to work with. There are instances and occasions where we are successful, where the victim is successful in reaching out and having the images removed. Some of the social media platforms also police themselves. But the challenging thing is, depending on the image, depending on the level of, I guess, forgiveness from the social media companies that the victim experiences, it's really kind of a hit or miss. So there is no real guaranteed avenue in order to get them to take it down. And for example, it depends on the nature of the image as well. The image might be very suggestive, and it might be something that shames and embarrasses the victim. However, within the standards of the social media platform, they might not deem that it's necessary that they remove that or take that down.
If these were illegal, like under this law, do you know if those social media platforms have a different stance? And this might be a question for the bill sponsor, or like when this passed in California, did it allow victims of this crime to be able to contact like a Facebook or a Meta and say, please, you have to take this down, you're now posting illegal images?
Jason Woodard for the record, Nevada Sheriffs and Chiefs. I don't want to misspeak on behalf of the social media platforms. I can tell you that we seem to garner more attention and cooperation when we are able to cite the law when working with the social media platforms to try and curtail this type of harassment.
I think we have another one from Senator Orenshaw.
Thank you for your indulgence, Chair. And just a quick question. When you get a case like this, is it an expert that you need to bring in to try to find out whether this is a computer-generated image versus what we're talking about, someone who's a dead ringer for the person who's being harassed? Is that something your officers can tell the detectives who are handling it, or do you need to have some expert with experience like in computer science, that kind of thing, about AIs and deepfakes and that kind of thing, to tell whether the image has been made by a computer versus something staged with someone who's a dead ringer for the person being harassed?
Jason Woodard for the record. Senator Orenshaw, in this particular type of scenario, most commonly what we'll do is first speak to the victim and say, okay, is this an actual image of you? And in those scenarios that I'm familiar with, and in my experiences, from time to time there will be something that is off. There is a distinguishing feature or possibly a tattoo that's not included, something along those lines, so they attest to that. But because it's this AI-generated image, typically the case does not move forward any further than that. Now, I could imagine if ultimately you were to bring your case to the point of wanting to submit it to a prosecutor for prosecution, it might be necessary to vet the photo and have an expert look at it in order to establish that it was generated. But that's far beyond my scope of knowledge as far as how that goes.
Thank you. Thank you, Chair.
I think we've exhausted the questions, but I really do appreciate you being willing to answer them, even though it's not your bill. So thank you.
Of course, thank you.
And please, go ahead with your testimony in support.
Good afternoon, Chair and members of the committee. My name is Joshua Martinez. I represent the Las Vegas Metropolitan Police Department, JOSHUAMARTINEZ. We appreciate Senator Stone for bringing this bill forward, and we're here in support of the bill. This deals, I know the committee has had conversation about the child aspect of things. This deals with 18 years old and older, but this would be a tool that we would be able to use to keep up with what's occurring out there in the AI world. It would help our investigators charge suspects with harassment and sextortion when the victims are over 18 years of age. So I appreciate your time, and we're in support of this bill. Thank you.
Thank you, Chair, members of the committee. For the record, Mike Cathcart, C-A-T-H-C-A-R-T, representing the City of Henderson. We're supportive of the bill and want to thank the sponsor for bringing this forward, and we are in agreement with the comments of the District Attorneys Association and the Nevada Sheriffs and Chiefs. Thank you.
Good afternoon, Madam Chair, members of the committee. Edith Duarte for the record, D-U-A-R-T-E with Western Public Affairs, today representing TechNet in support of this bill. The bill ensures that individuals who misuse artificial intelligence to create, distribute non-consensual intimate imagery, commonly known as revenge porn, can be held accountable. Our member companies are committed to combating this harmful content through innovative detective tools and partnerships with law enforcement and organizations like the National Center for Missing and Exploited Children. We believe that this bill is a reasonable and necessary step to protect victims and hold offenders accountable. We urge the support of this bill. Thank you.
Madam Chair, members of the committee, my name is Janine Hansen. I'm the state president of Nevada Families for Freedom. We very much appreciate Senator Stone bringing this bill, and I appreciate very much the questions that you've asked and the answers and all the testimony that we've heard today. We feel it's an important bill to fill in a place that's missing to protect innocent people from exploitation by others, and we want to support the bill. Thank you.
All right, thank you all for your testimony. I don't see anybody else coming forward in Carson City or Las Vegas to testify in support, so we will go to the phones, please, for testimony in support of SB 213.
Thank you, Chair. If you would like to testify in support of Senate Bill 213, please press *9 now to take your place in the queue. Chair, the public line is open and working. However, there are no callers wishing to provide testimony at this time.
All right, then we will go to testimony in opposition to SB 213. Anybody wishing to testify in opposition is invited to the front here in Carson City or Las Vegas now. I do see somebody coming forward, so please go ahead whenever you're ready.
Good afternoon. Angela Knott from the Washoe County Public Defender's Office, ANGELAKNOTT. We definitely understand the need to fill in this gap in what we like to call the revenge porn statute. And we really appreciate some of the language that is provided in this bill. We really like the identifiable persons language and that they have the carve out on page 3, lines 40 to 41 about juveniles not being included in this bill. So we really support those strong language additions to this bill. But we can't support the bill. As we were listening today to the presentation, I think more questions were raised for us than answered, and basically on the consequences of this bill and how this bill will really be prosecuted in the real world. We definitely have some concerns on page 2, lines 13 through 17. There's some confusion on our part on the language, and I think the language needs to be addressed. I think on page 3, when we're doing the intent, I think that's pretty well thought out. But as a whole, the language, I think, would lead to unintended consequences, and I would be interested in seeing maybe some amendments to this language. Thank you.
Good afternoon, Paloma Guerrero, PALOMA GUERRERO, on behalf of the Clark County Public Defender's Office. We agree with our colleagues from Washoe County, and I just want to highlight, we're to say in opposition with the language that we like in this bill, which is the identifiable minor aspect of it. And this language of identifiable minor is important because it also mirrors what they're doing on the federal side. That has passed constitutional scrutiny over there. And even with the language of identifiable minor, prosecutors are still getting convictions. So it isn't making it harder for people to be brought into court for them. Thank you.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. We're in opposition of this bill as well. I echo the previous comments made in opposition. I have a lot of concerns because of the discussion that's between the presenter and you members. There's just some unanswered questions. I mean, it's a good bill, but it's not quite there, I guess. So, thank you.
All right, I don't see anybody else coming up in opposition in Las Vegas or Carson City, so we'll go to the phones, please, for opposition on SB 213.
Thank you, Chair. The public line is open and working. However, there are no callers wishing to provide testimony in opposition at this time.
Okay, then we will go to testimony in neutral on SB 213. Anybody wishing to give neutral testimony is invited to do so now. I don't see anybody coming forward in Carson City or Las Vegas, so we'll once again go to the phones for neutral testimony.
Thank you, Chair. The public line is open and working. However, there are no callers wishing to provide testimony in neutral today.
All right, then that brings us to the conclusion of testimony. If the sponsor would like to make any closing remarks, now is the time.
Thank you, Madam Chair and Committee. I appreciate your consideration of SB 210. I think a lot of great questions were asked today, and I'll say that I'm very happy to work with the opposition if we can come up with some language that can bring them on and being in support. SB 210 seeks to address the evolving nature of digital imagery and misuse, ensuring that the law keeps pace with technological advancements and provides adequate protection against the unauthorized dissemination of intimate images. By addressing these areas, SB 213 strengthens legal protections against the misuse of intimate images, thereby enhancing public safety and privacy. I thank you for your consideration and your time today.
Thank you, Senator Stone. It's certainly been my experience in general and with this bill that you're very open to feedback and conversations with anybody who has concerns about the bill, and I would encourage those who have them to meet with you. And with that, I will close the hearing on SB 213. That brings us to our bill draft request introductions for the day. We have 3 of them for the committee this afternoon. All 3 of them are on the desks of the members. And we will start with the one that is on the top of the pile for me, which I am guessing is also for you. And that is BDR 3-1022. This is a provision relating to civil liability. As a reminder, a vote to introduce the bill doesn't indicate that you support or oppose the bill itself, just that you agree to introduce it on behalf of the committee. I'll open it up for any questions or discussion on this BDR.
No questions, Madam Chair. Move for the introduction.
Second.
All right, we have a motion from Senator Flores, a tie for second between Senator Wynn and Senator Orenshaw. I will let the record reflect that Senator Orenshaw wins this one. And with that, any discussion on the motion? All right, then all in favor say aye. Aye. Any opposed, nay. All right, by unanimous decision, we will be introducing BDR 3-1022. That brings us to BDR 12-901. This is a bill relating to independent administration of estates and probate. Are there any questions or discussion on the BDR itself?
No questions, Madam Chair. Move for the introduction.
All right, we have a motion to introduce BDR 12-901. This time we have a second from Senator Wynn. And any discussion on the motion? All right, all in favor say aye. Aye. Any opposed, nay. By unanimous vote of those present, we will be introducing BDR 12-901. And that brings us finally to BDR 14-492. This BDR essentially creates the Office of Alternate State Public Defender and Office of Post-Conviction Counsel within the Department of Indigent Defense Services. Any questions or discussion on the BDR?
No questions, Madam Chair. Move for the introduction. Excuse me.
All right, we have a motion to introduce BDR 14-492. All right, we have a second from Senator Orenshaw. Any discussion on the motion? Okay, all in favor say aye. Aye. Any opposed, nay. And again, by unanimous vote of those present, we will be introducing BDR 14-492. With that, we will move on to the final item on our agenda, which is public comment. Anybody wishing to give public comment is invited down to the front of the room here in Carson City or Las Vegas now. Please go ahead whenever you're ready.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. I know that I have been before you discussing SB 66. I know it's coming up on, I believe, Thursday. But I wanted to give you a little update on some information I think that you should need to know. And in the future, you know that I had put in a proposed amendment to this bill. It was a factual innocence posthumous petition. Well, Attorney General Ford is not going to support it once it wasn't germane to the bill, the discussion. Anyways, it's possible that it could appear in 2027 or maybe the interim. But recently, last week, March 12th, the retired Supreme Court Justice Cherry gave a great interview with Veterans in Politics, the talk show, discussing wrongful convictions. He brought up the Fred Steese case, and that when they were asking why aren't prosecutors prosecuted, and he says, well, district attorneys don't arrest DAs. And as far as the disciplinary action goes, because if they're withholding evidence from cases, prosecutors, they should be held accountable. Well, they're not. The disciplinary action with the state bar, they tend to protect their own. So unless the legislature change and creates a law to the state bar to allow those who have withheld exculpatory evidence from cases be disbarred by law, then there's really nothing that they can do with that. And so these are some of the things I wanted to bring to your attention. I ask that you go and listen. It starts around 25 minutes. It's a great, great interview with Justice Cherry. It sheds a lot of light on those who've been wrongfully convicted and how the system actually helps those who cause the issue of prosecutors withholding evidence and how far they go to protect them. And so that's why nothing ever becomes anything. You have prosecutors who continue to keep practicing law because they're not being disbarred, go on to become district attorneys, judges, and justices. And we need to stop that. We can't just let them get away with stuff like this. They have to be held accountable. If it were us, we would be held accountable. So thank you.
All right, thank you. I don't see anybody else coming forward to make public comment today, so we will go to the phones for public comment.
Thank you, Chair. If you would like to provide public comment, please press *9 now to take your place in the queue. Chair, the public line is open and working. However, there are no callers wishing to provide public comment at this time.
All right, then that brings us to the conclusion of our meeting. We will be meeting here again tomorrow, same time, same place, and until then, we are adjourned.